So let's begin by thinking about the origin of urban land rights. Urban land and property rights encompass all of the ways that people define their relationships to occupy, to use, to develop, and to profit from land. Every individual and household in an urban region must occupy some land, must occupy some built space with enough security to feel a sense of permanence. With security, they can organize and plan productive activity, they can invest, they can carry out their daily activities without fear of eviction, without fear of harassment. In addition, the right to occupy and use urban land allows a person or a household or an enterprise to have an address in the city. This can give access to a job, can give access to vote, can give other civic and social privileges, such as the ability to enroll a child in school. In most cities, tenure rights originate from the process of urbanization, which may be a gradual and well-organized formal process, or maybe an informal process of unauthorized subdivisions and chaotic settlement. In either circumstance, the actions of urbanization bring to an end the system of rural tenure and put into place a new regime of urban rights and a new distribution of those rights on the land. In some unfortunate cities, the transition from an old regime of property holdings to a new regime of property holdings takes place as a result of a disaster or a war. Buildings and infrastructure are destroyed, land occupants are displaced, records showing proofs of rights go missing, administrative systems break down. The post-disaster resettlement and reconstruction create a new pattern of locations, of relationships, all of which require the adjustment of the forms and the conditions of land tenure. In other recent cases, certain nations have deliberately ended one regime of land tenure and have superimposed a new regime. They've done this in order to restore rights that were previously confiscated, or to bring the system of property relations into a more modern form to meet modern economic conditions. We've seen this kind of a deliberate change in regimes of land rights in Eastern Europe back in the 1990s. We've also seen the gradual change in China, which has introduced property rights and contract rights as part of its land tenure system. In all three scenarios, urbanization, disaster, and deliberate change in property rights, it should be recognized that the land and property rights are not defined and imposed as abstract principles. Instead, they emerge out of the dynamics of population movement, out of the economic growth and decline conditions, out of practical responses to social and to environmental changes. Their form and the content of rights, the obligations and limitations on those rights, all are shaped by the local context. So let's now turn our attention to look quickly at some typical processes of formal and informal urbanization, and at the different forms of tenure that may emerge from each. In most nations, the laws on urban planning describe a process with 5 steps that are required to transform rural land to urban land, or that are required to change a zone of the city with obsolete uses into a modern zone. The first step in this formal process is usually an official act, which identifies a zone and then authorizes the preparation of an urban plan. The plan defines permitted uses. It defines the scale of development, defines the pattern of streets and of blocks, and the locations and the capacities of infrastructure. Second, once the plan is put into place, the existing rural or the obsolete land uses are cleared away, and the new pattern of blocks, streets, and infrastructure lines are set down on the land. This usually requires the transfer of some lands from private control to public control, so that streets can be made straight and infrastructure lines put in the most efficient places. Third, the infrastructure is installed. Fourth, once that's done, the landholders and the developers are allowed to subdivide the blocks into land parcels, following the standards of the regulations for the size, the placement of land in relationship to infrastructure lines. Finally, the subdivided parcels are sold, leased, or transferred to the users, the households and enterprises, or they're transferred to developers who are given the right to build and then resell or transfer. At the end of this process, the households and enterprises that receive the land parcels also receive instruments of land tenure that fall into four categories. First, there can be contracts, which are two-party instruments signed by a buyer and a seller, or by a leaseholder and a lessee. They can take the form of purchase and sales agreements, of deed transfers, of leases, or other types of tenancy agreements. The documents usually carry a notary stamp or an official signature that identifies the parties or that certifies that the state or a municipality has given them permission to make the agreement. A second category involves unilateral administrative grants or permits. These come from the state or municipality. They can include use and occupancy permits, certificates of resettlement, leaseholds under state ownership, or rights of allocation of properties that are understood to come from the Commonwealth stock of lands of the nation or of the community. Third, in some nations, there's a combination of contracts and administrative forms that are joined together. These reflect the idea that the state is both the regulator of the horizontal relationships between the two parties, or that the state has a co-ownership or a superior right in the land that must be transferred downward to the new landholder. Finally, in nations that have civil law or common law, there are property titles. When registered, these rights become binding against all third parties and against the state. Of course, what we've just described is the ideal that's often envisioned in the law, but that in many cases, few urban zones are able to fully complete and are able to fully follow. This is because the formal urbanization process is often slow, complex, and expensive. Most often, urbanization, and particularly in situations where poor households are involved, the urbanization is backwards. It follows 3 steps, each of which ends in a different set of tenure forms. The first step in the informal process usually involves the squatter settlement or an unauthorized subdivision of land on the periphery of the city or in a vacant urban zone. The existing landholder or the squatters occupy the land. They mark it in some way to divide it into parcels. They may or may not leave a rudimentary system of streets. They may reserve lands or not. They may anticipate infrastructure systems and leave reserved lands for those. Settlement on the parcels begins with the squatters, or money changes hands. The parcels are transferred to households and to enterprises, using usually informal and simplified documents that mimic the usual legal, administrative, or contractual forms. One example we can cite is Lesotho, where on the periphery of the cities, the rural chiefs subdivide agricultural fields. They take payment and they give each new landholder something called a Form C. The Form C was a document that back before 1980, the rural chiefs had the authority under the law to issue. They lost it with the change in the Land Act in 1980. However, since then they've continued to issue the documents. They're all backdated to 1979. Another example we can talk about is Benin, where a seller with customary rights and a buyer sign a contract. It's called a contract convention sous sangue, meaning the two parties each put their signature on it. It has no notary attestation, has no other verification of the parties. However, if the parties want, they can go to the mayor's office, pay a small fee, and the mayor will sign an attestation to attach to the document. And he may also order that the contract be placed in the municipal archives. The security provided by these hybrid forms depends on the social, political, and economic conditions in the area. Despite the obviously illegality of the Lesotho Form C, it actually gives quite strong security. This is because in Lesotho, the ownership of all land is considered to be vested in the king. Therefore, all subordinate rights to the land are under the superior authority of the state. Consequently, in practice, it's only the state that has the power and the authority to evict anyone or to change the terms and conditions of the subordinate right. This is seldom done, both for political reasons and because in Lesotho, the urban areas are actually quite small. The capital city of Maseru has only 300,000 people. So consequently, there's plenty of land. Even in the illegal subdivisions of that city, the land parcels are laid out quite generously in size, and space is kept for wide streets, for public facilities, and for infrastructure lines. With that pattern of layout of settlement, in fact, there are very few disputes over land, and if they arise, they can be easily settled or compensated by finding some other land that's nearby that can be granted. By contrast, Benin undertook a mass titling project between the years 2006 and 2011. At the end, fewer than 500 urban titles were issued out of a target of 30,000. The reasons for the weak results were the dense pattern of settlement in the urban zones. Parcels had been reduced to 300 or 350 square feet after land was taken for streets and reserves. In addition, Benin's French colonial land law required each landholder to produce very detailed proofs of rights and proofs that there were no hostile claims against the property. The weak contracts and the many unresolved ancient customary rights were obstacles for most landholders. So, based on this experience, what have we learned? The positive and negative results of past projects have been studied in great detail by the researchers and practitioners. They've found that in many cases there have been positive outcomes. In some zones, poor households received improved services and now perceive themselves to be more secure. In some zones, the results have been improvement in housing quality, investment in new housing. In some zones, households and enterprises have used land as collateral for mortgages. However, by contrast, some zones have seen the displacement of poor families as rents and land prices have risen. And as we cited above, there are many of the projects that led to very few numbers of finalized titles.